My name is Robert Hayes, and I was 67 the year. My son told a lawyer I wouldn't remember the conversation we were having. He said in my kitchen. In the house I had lived in for 32 years. Standing 3 feet from the hallway, where I was holding a glass of water I had gone to refill, listening to every word through the gap in the door. Dad won't remember anyway. Just draw up the papers and I'll handle the rest. The lawyer, a man I had never met, whose name I would learn later was Bradley Kern, said something I couldn't quite hear. Then my son Dylan laughed. Not nervous laughter, the kind that comes from certainty. He's got mild cognitive impairment, diagnosed 4 months ago. Half the time he can't remember what he had for breakfast. He's not going to contest anything. I stood in that hallway with my hand on the doorframe and the glass shaking slightly in my grip. And I understood in a way I had been avoiding for months that my son had been waiting for this. Not for me to get sick, but for me to become manageable. I need to tell you what mild cognitive impairment actually means, because what it meant to my neurologist and what it meant to my son were 2 completely different things. Dr. Patel had diagnosed me in February after 6 months of forgetting names, missing appointments, losing track of conversations midstream. The kind of forgetting that crosses from normal aging into something worth documenting. MCI, she called it. Mild cognitive impairment, not dementia, not Alzheimer's, at least not yet. A middle space where memory struggles but function remains. Some people stay in that space for years. Some progress. Nobody knows which category you'll fall into until time makes the decision for you. I forgot small things. I wrote everything down. I set alarms. I adapted. What I did not forget was how to read a contract. I had spent 34 years as a civil engineer reviewing site plans, construction bids, and liability clauses. I knew how to find the sentence that mattered in a document designed to hide it. I did not forget how to balance a checkbook. I had been managing my own finances since I was 19 years old. Through a marriage, a mortgage, my wife's illness, and the years after her death, when the house felt too big and too quiet, and I kept the books anyway because numbers don't leave. I did not forget who my son was. I just forgot for a few years to notice what he was becoming. Dylan was 39. He worked in pharmaceutical sales, a job that required a company car and expense account, and the kind of aggressive optimism that wears people down until they buy something just to make the pitch stop. He had been married twice. The first marriage ended when he was 26, quickly, no children, no detail ever offered. The second marriage, to a woman named Vanessa, had produced 1 child, my grandson Ethan, now 12, and a lifestyle that required more income than Dylan's sales commissions could apparently sustain. They lived in a house in Frisco with a mortgage I knew was adjustable because Dylan had mentioned refinancing twice in 3 years. Vanessa didn't work. Ethan attended a private school that cost more annually than my first car. I had helped them once, 2 years ago, when Dylan called and said they were 3 months behind and the bank was sending letters. I wrote a check for $18,000. Dylan said he'd pay me back. He thanked me. He didn't pay me back. I didn't ask. He was my son. That was the logic I used then. I had started noticing the pattern 6 months ago, before the diagnosis, before Dr. Patel used the words mild cognitive impairment in a sentence that reframed my entire future. Dylan's visits had increased, not in warmth, in frequency. He came by the house in North Dallas every week, sometimes twice. He asked questions. How was I feeling? Was I keeping up with the bills? Had I thought about what I wanted to do with the house long term? The questions felt thoughtful until I realized they were auditions. He was testing how much I remembered, how sharp I still was, how long I had before he could stop asking and start deciding. Then the diagnosis came, and the questions stopped entirely. The day I overheard the conversation in my kitchen, Dylan had told me he was bringing someone by to help me organize my estate planning. He said it the way you'd say you were bringing by a plumber. Casual, necessary, already decided. I said I didn't need help with estate planning. I had a will. I had accounts in order. Dylan smiled. Dad, you've got MCI. Let's just make sure everything's buttoned up in case things progress. In case things progress. That phrase lived in my head for 2 days. The lawyer arrived at 2 on a Thursday. Dylan introduced him as Bradley Kern, estate and elder law. I shook his hand. I offered coffee. I sat at my own kitchen table and watched my son position himself between me and the door like he was managing a client meeting. Bradley opened a briefcase and pulled out documents I hadn't asked to see. Then I excused myself to refill my water glass, and I stood in the hallway and listened. I stood in that hallway for 4 minutes. I know because the kitchen clock ticked loud enough to hear from the doorway, and I counted without meaning to, the way you count things when your mind needs something concrete to hold while everything else shifts underneath it. Bradley Kern's voice was low and professional, the voice of a man who had done this before and had learned to keep the volume at a level that didn't carry. But Dylan's voice carried. It always had. He'd been the loudest person in every room since he was 4 years old and had decided volume was the same thing as authority. The documents are straightforward, Bradley said. A durable power of attorney naming Dylan as sole agent for all financial and healthcare decisions. A trust amendment transferring primary asset control to the named trustee upon execution. And the house, Dylan said. The property can be placed in the trust at the same time. One transaction. Clean. Dylan said something I didn't catch. Then, Dad's signature is all we need. He paused. Just keep the language simple. He gets confused with anything too detailed. I pressed my back against the hallway wall. I had written the language for 3 dozen construction contracts in my career. I had reviewed liability clauses that law firms had spent weeks drafting. I had sat across from city engineers and municipal attorneys and argued line items in documents designed specifically to obscure what they were doing. I got confused with anything too detailed. I stood in my hallway, and I was not confused at all. I went back to the kitchen. I set my water glass on the counter. I sat down at the table, and I looked at the documents Bradley Kern had laid out, and I said, "Can I read these before I sign anything?" Bradley said, of course. He slid them toward me. Dylan shifted in his chair. "Dad, it's pretty standard. Bradley can walk you through it." "I'd like to read them myself," I said. I kept my voice level. I spent 34 years reading documents that were called standard. I read every page. The durable power of attorney was structured to activate immediately, not upon incapacity, immediately, the moment I signed. That meant Dylan could make financial decisions on my behalf starting the same afternoon, while I was sitting in my own kitchen in full possession of my faculties. The trust amendment was worse. It transferred the house into a trust with Dylan named as sole trustee with full authority to sell, encumber, or transfer the property. My role was listed as trust beneficiary, which sounded generous until you understood that a beneficiary has no control over what a trustee does with an asset. I would own the house, the way a passenger owns the car they're riding in. At the bottom of the amendment, a distribution clause. Upon the grantor's death, trust assets to be distributed equally among the trustee's immediate family. Dylan's family. Not my estate, not my grandson Ethan individually. Dylan's household managed by Dylan. I set the documents down. "Bradley," I said. "What firm did you say you were with?" "Kern and Associates, Elder Law and Estate Planning." "How did my son come to retain your firm?" A pause. Dylan answered before Bradley could. "I found him online, Dad. He comes highly recommended." I nodded. I stood up. I told them I needed time to review the documents with my own attorney before signing anything, and that I'd be in touch. Dylan's jaw tightened. "Dad, we've already discussed this. This is just to protect you in case I progress," I said. "I remember." I held the door open. Bradley collected his briefcase. He had the expression of a man who had just realized the meeting had not gone the way he'd been told it would go. He shook my hand on the way out. His grip was careful, the way people grip the hands of someone they've been told is fragile. I was not fragile. Dylan lingered, his hand on the doorframe, his voice dropping to the register he used when he wanted to sound reasonable. "Dad, I'm trying to help you." "I know what you're trying to do," I said. "I'll call you tomorrow." I closed the door. I went to my desk in the study. I opened the bottom drawer where I kept important papers. Behind the manila folders and the tax records, a business card I had been given 8 months ago by my neighbor Frank, who had used the firm when his wife needed a guardianship filing. Patricia Odom. Elder Law and Estate Litigation. Odom and Associates. I had held onto the card without knowing why. Now I knew why. I picked up the phone. Patricia Odom answered on the second ring. Not her receptionist, her, which told me either she ran a small operation or she was the kind of attorney who picked up her own phone because she'd learned that the calls worth taking didn't always come during business hours. I told her my name. I told her Frank Delgado had given me her card. I told her I needed to speak with someone about documents my son had presented for my signature that afternoon. She was quiet for exactly 3 seconds. "Can you come in tomorrow morning?" she said. 8 o'clock. I said yes. I spent the rest of that evening at my desk with a legal pad and a blue pen, writing down everything I remembered from the documents Bradley Kern had laid on my kitchen table. The activation clause on the power of attorney, the trust amendment language, the distribution clause at the bottom. I wrote it all from memory. Then I wrote the timeline. Dylan's increased visits over the past 6 months. The questions about the house. The $18,000 I had given him 2 years ago that had never been repaid. The diagnosis in February. The visits that stopped being warm and started being assessments. By the time I finished, it was 11 at night and I had 4 pages of notes in handwriting that was steady and clear and looked nothing like the handwriting of a man who couldn't remember what he'd had for breakfast. Patricia Odom's office was on the 14th floor of a building on McKinney Avenue in uptown Dallas. The waiting room had framed degrees from UT Law and a small shelf of elder law texts that looked read rather than decorative. She was 58, direct, with reading glasses she took on and off as she moved between documents and conversation. She had the manner of someone who had spent decades in rooms where families argued about money and had long since stopped being surprised by any of it. I handed her my legal pad. She read it without interrupting me. When she finished, she set it down and looked at me over her glasses. "Mr. Hayes," she said, "before we discuss the documents, I need to ask you something directly. Have you signed anything for your son in the past 12 months? Any document, regardless of what it was described as?" I said no. "Are you certain?" "I'm certain." I told her about the $18,000 check 2 years ago, but clarified it was a personal loan, not a legal document. She nodded. She typed something on her laptop. Then she turned the screen toward me. "Do you recognize this filing?" I leaned forward. It was a Denton County probate court record. A petition for guardianship filed 6 weeks ago. The petitioner was Dylan Hayes. The respondent was Robert James Hayes. I sat back in my chair. "He'd already filed," I said. "He filed a petition 6 weeks ago claiming you lack the capacity to manage your financial and personal affairs." She kept her voice even. "The way doctors keep their voices, even when delivering information they know, will change a person's understanding of their own situation." He attached your MCI diagnosis from Dr. Patel's office and a sworn statement from a physician I'm not familiar with, a Dr. Marcus Webb, attesting to significant cognitive decline. "I don't know a Dr. Marcus Webb," I said. "I know." She folded her hands. "Dr. Webb appears to have submitted a clinical assessment based on a records review rather than a direct examination. It's a method sometimes used in guardianship petitions when the petitioner anticipates the subject will resist a direct evaluation. He had someone assess me without meeting me, based on records Dylan provided to them. Yes." I looked at the ceiling, the window, the framed degrees on the wall. My son had filed a legal petition to have me declared incompetent 6 weeks before he brought a lawyer to my kitchen to present documents he needed me to sign. The kitchen visit wasn't the plan. It was the backup plan. If I signed willingly, the guardianship petition was unnecessary. If I didn't sign, the petition was already in motion. He had covered both outcomes. Patricia was watching me process it. She didn't rush the silence. When I looked back at her, I asked the question that mattered most. "What's the timeline on the petition?" "A hearing has been scheduled," she said. 41 days from today." I put my hands flat on the desk the way I used to put them flat on a drafting table when I needed to think through a problem that had more variables than the obvious ones. "What do I need to do?" I said. She pulled a legal pad from her drawer, the same yellow kind I used myself. "First," she said, "we get you a formal neuropsychological evaluation from an independent examiner, not Dr. Patel's records, which Dylan already has access to, but a full current assessment that documents your actual functional capacity in clinical terms a judge can rely on." She turned to a fresh page. "Second, we file a response to the petition, formally contesting it with your own representation on the record. Third," she looked at me, "we look at everything Dylan has touched. Bank accounts, any accounts you share access on, your insurance policies, the deed to your house, anywhere his name appears that you didn't put it there yourself." She said that last sentence carefully. "Anywhere his name appears that you didn't put it there yourself." I felt something cold move through my chest. "What are you expecting to find?" I said. She picked up her pen. "I'm not expecting anything, Mr. Hayes. I'm preparing for everything." She started writing. Patricia's paralegal spent 3 days pulling records. I gave her written authorization for everything. Bank accounts, insurance policies, the deed to the house, investment accounts, utilities. Every financial instrument attached to my name going back 4 years. She was thorough in the way people are thorough when they've done this before and know where the surprises tend to hide. The surprises were not hiding particularly well. The first finding came from my secondary checking account, a savings account I had opened in 2019 to hold the proceeds from my wife Margaret's life insurance policy. $94,000, set aside deliberately, untouched, the money I thought of as Margaret's money, even though her name was no longer on anything. Dylan's name had been added as a joint account holder 14 months ago. I had not added it. The signature on the authorization form was mine. I looked at it for a long time. The R was wrong. I have a specific way of writing the capital R in Robert. A small loop that closes at the base, a habit from the drafting work, where precise, consistent lettering mattered. The signature on the form did not have the loop. It was close, but it was not mine. Patricia looked at it across the desk without changing her expression. The second finding was the insurance policy, a whole life policy I had held since I was 34. Margaret was the original beneficiary. After she died, I had updated the beneficiary designation to my grandson Ethan, specifically with the instruction that the funds be held in trust until he turned 25. The beneficiary had been changed 11 months ago. Current beneficiary Dylan Michael Hayes. The change form had been submitted by mail with a signature that had the same problem as the bank authorization. Close. Not mine. Patricia set both documents side by side on her desk. Mr. Hayes, she said, I need to ask you directly. Did you at any point give Dylan access to your mail, your financial documents, or any signed blank forms? I thought about it. 6 months ago, Dylan had offered to help me organize my filing system. He had spent an afternoon in my study, going through old paperwork, separating what he called clutter from what he said I actually needed to keep. I had let him because it seemed like the kind of thing a son did for an aging father, and I had wanted, in that particular month, to believe that's what it was, I told Patricia. She wrote it down without comment. Then she picked up her phone and called someone. She used the word forensic and the phrase questioned document examiner and asked for availability within the week. When she hung up, she said, we're going to get both signatures independently analyzed. If they're confirmed as forgeries, this becomes a criminal matter in addition to the guardianship contest. I sat in her office with my hands flat on my knees. My son had forged my signature twice that I knew of. Dylan called me on a Thursday evening. I answered because Patricia had told me to keep our communication normal. Don't change your patterns, she said. Don't let him know you've retained counsel yet. Let him believe the kitchen visit is still the last significant thing that happened. Hey, Dad. His voice was easy, practiced. How are you feeling? Fine, I said. Good day, good. Listen, I've been thinking about those documents. I know it seemed like a lot at once. Maybe we slow it down a little. Come at it in pieces. He paused. I just want to make sure you're protected. I appreciate that, I said. Can I come by Saturday? We could have lunch, just the two of us. I said Saturday was fine. I hung up and sat in the living room in the chair I had sat in every evening for 32 years and looked at the wall where Margaret's photograph still hung above the fireplace. She had been gone for 6 years. She had known Dylan his entire life and loved him completely and seen. In the last years before she got sick, something in him that she mentioned to me once in the careful language of a woman who didn't want to be right. He takes, Robert. She'd said it quietly, not maliciously. The way you name a weather pattern. He takes, and he doesn't notice he's doing it. I had told her she was being too hard on him. I sat in the chair and looked at her photograph and said the sentence out loud to no one. You weren't being too hard on him. Saturday arrived. Dylan came at noon with sandwiches from a deli I liked, turkey on sourdough, the kind of gesture that costs $12 and is meant to signal consideration. He set them on the kitchen table and poured 2 glasses of iced tea and sat across from me with the ease of a man who believes the room is still his. I let him talk for 20 minutes. About Ethan's school, about a sales territory expansion, about Vanessa's plans to renovate the kitchen in Frisco. Then I put my sandwich down. Dylan, I said, tell me about the account at Frost Bank. The ease left his face in one clean movement, like a tablecloth pulled from a set table. He looked at me. He didn't speak. Tell me about the beneficiary change on the life insurance policy. I said. The kitchen went very quiet. His hands were flat on the table, the same posture I used when I was working through a problem. I recognized it and felt something I hadn't expected. Not anger, grief. The specific grief of watching someone you raised use what they learned from you against you. Dylan, I said quietly, I know about the guardianship petition. I know about Dr. Marcus Webb. I know about both signatures. He opened his mouth. I held up one hand. I have an attorney, I said. I have a neuropsychological evaluation scheduled for next week with an independent examiner. I have a forensic document analyst reviewing both authorization forms, and I have 41 days until the hearing. He stared at me. I picked up my sandwich. I suggest you get your own attorney, I said. A good one. He left 20 minutes later without finishing his lunch. I heard his car back out of the driveway faster than necessary and disappear down the street. I cleared the table. I washed the glasses. I sat back in my chair. I was not confused. I had never been confused. The neuropsychological evaluation took 4 hours, Doctor. Sandra Obi, independent examiner, administered every standard assessment the field had developed for measuring functional cognitive capacity, memory sequencing, executive function, processing speed, verbal reasoning, spatial orientation. When she submitted her report to Patricia's office 12 days later, her clinical conclusion was 3 sentences. Mr. Hayes demonstrates intact executive function and above-average performance on complex reasoning tasks. His memory deficits are consistent with mild cognitive impairment, but do not impair his ability to manage his personal and financial affairs. He retains full legal capacity. The forensic document examiner submitted her report 2 days after that. Both signatures were confirmed as forgeries. The guardianship hearing was held on a Tuesday morning in a Denton County probate courtroom with wood paneling and fluorescent lighting, and the particular quiet of a room where families come apart in front of a judge who has seen it before. Dylan sat at the petitioner's table with an attorney named Gareth Moore, who had the look of someone who had reviewed the case file the night before and was already recalibrating. I sat at the respondent's table with Patricia. The judge was a woman named Hon, Carol Tran, 61, who read documents the way I read them, line by line without rushing. Patricia submitted 4 items: Dr. Obi's evaluation, the forensic handwriting report, the Frost Bank authorization with the confirmed forged signature, the insurance beneficiary change form with the second confirmed forgery. Dylan's attorney requested a recess after the second item. Judge Tran denied it. She read everything. She asked Patricia 2 questions and Dylan's attorney 1. Then she set the documents down and looked at Dylan directly. This petition is dismissed, she said. The respondent retains full legal capacity and full authority over his personal and financial affairs. She paused. She referred both forged documents to the Denton County District Attorney's Office for review. The gavel came down. The insurance beneficiary was restored to Ethan within the month. The Frost Bank account had the joint designation removed the same week as the hearing. A fraud alert was placed on every financial account attached to my name. Dylan did not call me after the hearing. He sent 1 text 3 days later. 2 words: "I'm sorry, I read it, I didn't respond." Some apologies are receipts for getting caught, rather than expressions of genuine remorse. And I had spent 34 years reading documents carefully enough to know the difference. The district attorney's office opened an investigation. I don't know where it ended. That became a matter I handed to Patricia and stopped tracking. Frank Delgado came over on a Thursday evening 2 weeks after the hearing. He brought a 6-pack, and we sat on the back porch watching the Dallas skyline go orange in the last light. He asked how I was holding up. I told him I was fine, I meant it. He said, "You know what got me about all of it. You heard him through that door, and you didn't say a word. You just went and got help." I thought about that. I told Frank what Margaret had said 6 years ago. He takes and he doesn't notice he's doing it. Frank was quiet for a moment. Then he said, "She was smart, your wife." "She was," I said. We sat on the porch until the light was gone. I remembered all of it. I always had.